we have to start criminal procedure code, and this new criminal procedure code came on enforcement on 1st of April 1974. 1st of April 1974 with the name Criminal Procedure Code 1973. Criminal Procedure Code 1973 came on enforcement on 1st of April 1974. See, why we required the procedure? It's a main question. So we having two machineries. One is the state authorities. State authorities means police and the government, and the another authority is the judiciary. So what is the role and function of both the organizations? As per Criminal Procedure Code, we having two main functions. First is to prevent the crime, and another, if the crime happened, then to punish or to do the justice. So prevention of crime and to punish for the crime, these are two functions of Cr.P.C. Okay, and the third function is maintenance. Later on it was added in Cr.P.C. because we want to give the fast justice to the females, to the persons who came to the court for the maintenance purpose and nothing else. So for the prevention of crime, we have some sections. These are section 106 to 124, 129 to 132, 144 to 153, 133 to 143. For the prevention of crime, we have some sections where we confer the power to the magistrate or to the police or to the administration. These are section 106 to 124, 129 to 132, 144 to 153, 144 to 153, 133 to 143, and finally maintenance 125 to 128. Except these provisions, all the proceedings we have to punish the criminal, either to do an investigation to find out the criminal, or to take a cognizance, or to inquire, or to inquest, or to do the trial, or to punish. After all, the purpose is started, or the act is started after the crime. But before the crime, we have to prevent the crime. It's the best solution. Prevention of crime. So the police, administration, as well as court, or whatever the authority we have, all bodies having a one function to prevent the crime. And we govern the prevention of crime by conferring the power to these type of authorities from section 106 to section 153 almost. Clear? Now the another question is this: in what type of penal laws we have to apply the procedure from this act, or the procedure conferred in this act, means in Criminal Procedure Code 1973. Actually, we have so many penal laws, as already we discussed on some other parts, that we have so many criminal laws. Criminal laws mean penal laws. And the main penal law is Indian Penal Code. A part of this Indian Penal Code, we have so many penal laws also. So on what type of laws or what type of penal laws we have to apply the Criminal Procedure Code? The answer is in section 4 and section 5. Section 4 is saying if the matter is covered by Indian Penal Code, we have to apply the proceeding from the Criminal Procedure Code as per section 4. So section 4 have two clauses. Section 4 clause 1, section 4 clause 2. So section 4 clause 1 is saying that if the matter is covered by the or penal laws or penal action is covered by Indian Penal Code, then we have to do the we have to apply the procedure from Criminal Procedure Code 1973. Is it clear? Along with section 4 clause 1, we have to read section 5 also. Means if there is any special provision or if there is any special procedure to investigate, to do the trial, to inquire or whatever, if there is any special provision, then we have to apply that special provision for a particular penal law. Like NDPS have their own procedure. Like Prevention of Corruption Act have their own procedure. Like POTA have their own procedure. Like TADA have their own procedure. NSA have their own procedures. So there is a lot of penal laws, those have their own procedure. If any law having their own procedure, then we will not apply the Criminal Procedure Code, we will apply the procedure for same. Nothing is the problem. But in absence of any proceeding in that special law, then what we have to do? How we will fill in the gap? Not got it. See, suppose if we have NDPS Act and NDPS Act have their own procedure to investigate, to inquire or to trial, but something is missing in NDPS, then what have to do? Section 5 is already saying that if there is any special procedure, then have to apply the special procedure. Cr.P.C will not apply on that. But if there is any gap, so what to do? Cr.P.C section 4 clause 2 is saying in that situation, in case of otherwise, then we can fill the gap. क्लियर है? तो क्या करना हमने? Simple thing. If there is any Indian, if the matter is covered by the Indian Penal Code, no doubt we have to apply this Criminal Procedure Code. If there is no procedure of any act, then the Cr.P.C. If any act have their own procedure, then no Cr.P.C, that procedure. And in case of fill in the blank, we have to read all the proceeding of a special procedure code with the Criminal Procedure Code. So, Criminal Procedure Code is a basic law for all type of penal proceedings. Clear hai na? Like we having section 167 of Cr.P.C. What it was saying? It was saying that have to complete the investigation within 60 days or within 90 days. If you will not complete the investigation within 60 or 90 days, then the accused is entitled to get the benefit of bail. But if we will cover that matter, especially by NSA, National Security Act, or by POTA, or by any terrorist act like Macoca, UP Coca, or any type of coca, then what to do? So we will apply that provision, and that these type of acts are saying that for the investigation purpose it may take time of 1 year or 2 years or 3 years, because these are the terrorist proceeding, these are the terrorist investigation, and for the purpose of terrorist investigation, this is the duty of the investigating officer to do some secret act. And if the accused will get the bail under section 167, then it may be very blunder for the investigation purpose. So in that situation, we will not apply the Criminal Procedure Code. We will govern all these things by that act. Like we have some acts covered by Article 22 of Constitution of India. 22 of Constitution of India. Preventive detention.